ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನಂದು?
ಪದ್ಮನಾಭ್, ನಿಮ್ದು ನಾಯ್ಸ್ ಬರ್ತಾ ಇದೆ, ಎಕೋ ಬರ್ತಾ ಇದೆ ನೋಡಿ.
ಇಕೋ ಬರ್ತಾ ಇದೆಯಾ?
ಎಕೋ ಬರ್ತಾ ಇದೆ, ನೀವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಬೇಡಿ. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ಡಿಸ್ಟರ್ಬ್ ಆಗುತ್ತೆ ಕೋರ್ಟ್ಗೆ. ನಿಮ್ ಸಿಕ್ಕಾಪಟ್ಟೆ ಎಕೋ ಬರ್ತಾ ಇದೆ, ಬೇರೆ ಡಿವೈಸ್ ಇಂದ ಕನೆಕ್ಟ್ ಮಾಡಿ.
ಸರ್ ಇವಾಗಲೂ ಎಕೋ ಬರ್ತಾ ಇದೆಯಾ?
One matter for admission, my lord, education institution. Now the renewal of recognition which was challenged by the appellant was rejected by the learned single judge. Now the academic year, I have to admit the students for the academic year. Therefore, in view of the urgency, my lord, Monday or Tuesday, my lord.
22nd. Lord, on the basis of an undertaking given by DC before this honorable court in contempt proceedings, Lord was pleased to pass an order directing the DC to disburse compensation to the landowners, please, my Lord. Up to now, they have not done. It's almost 4 months down the line.
After vacation.
Shortest accommodation.
Not possible.
At least a date be
Give some 10th of June.
10/6.
Yes.
Senior counsel Mr. Chidambaram is trying to log in. It's taking some time because of the change in platform. I'll just wait for him to log in, my lord.
Yes, Mr.
My lord, one more matter, contempt, my lord, contempt matter.
Yes. Serial number? Serial louder.
Serial number 39.
39. What do you want?
What do you want? Anthony?
What do you? Adjournment. 23rd of June as requested by learner petitioner.
My lord, one.
We do not have. When time permits, we will take in serial. In serial number, we will take.
Serial number 72.
70.
Petitioner.
72. What do you want?
I'll file a petition and the allowance to receive an application.
What is the request? Withdraw. You want to withdraw? Learned advocate miss. What is your good name?
Yesterday I had.
So and so, so and so. Shri Gaur.
Yes, ma'am.
For the petitioner, vendor's memo dated 4/4/25, which is taken on record, in which It is stated that the petitioner wants to withdraw the petition, seeking further liberty to file a comprehensive petition. Full stop. The petition is for him to be withdrawn and stand dismissed as withdrawn. Full stop. Since the court has not gone into the merits of the present petition, it will be permissible for the petitioner to file comprehensive petition as prayed for.
Serial number 35, my lord. Serial number 35. I appear on behalf of the complainant. May we please to, my lord, you permit me to file memo for withdrawal, my lord.
50.
35.
But like, what is a good name? Learned advocate Miss?
Name,
Amanda, I'll pass on it.
For learned advocate Rajesh Kumar S. Files memo dated 4/4/25. Whereby for the reason stated in the memo, the petitioner wants to withdraw the petition, permission is granted. The petition is dismissed as withdrawn. Full stop. Any subsequent development which may be adverse to the petitioner will give rise cause of action to be treated in accordance with law.
Your Lordship's permission, my lord. Who matters, my lord? Writ appeal. Matter has been dismissed for non-compliance of the office of the my lord. I made an application for recalling, my lord. Your Lordship could post it.
8.
Public.
Yes, Mr.
My lord, he is unable to.
My lord, one contempt matter, my lord, the writ petition was disposed of directing the respondent to implement rectify the revenue entries, my lord. Despite, my lord, 2-3 months, my lord, they have not taken any filed contempt petition.
After which,
My lord, serial number 34, my lord.
what is the urgency?
Higher court rejected the order 39 rule 1 and 2.
39?
39 1 and 2.
1 and after vacation.
My lord, serial.
Yes, madam.
My lord, the memo for posting, the commercial appeal, the trial court is passing order against us to pay a sum of 81 crores for a partner who has already retired this month. And the final hearing of it is tomorrow, 1940 on Monday.
Now we are filing at the last moment.
My lord, we tried filing, we finished the compliance, it was posted to not compliance.
Not tomorrow. 7th. 7th.
Serial number 75, not on the previous occasion.
75.
75. The learned government advocate had sought time for seeking instructions. The matter was listed, the main petition was listed before the learned single judge on 2/4. He has adjourned it to 15/4 minutes because CRC is considering the representation that was formed by the petitioners for relaxation of that provision. So it would reach finality if appropriate orders are passed for the single judge minutes. In light of that, they kindly be adjourned after vacation.
Beyond vacation, 24th of June as requested. Send over to 24th of June as requested. Yes.
Lord, learned senior counsel is trying to mention, he
Yes,
can
ma'am.
see, but
My lord, this is a contempt matter. Here, the question is, the urgency is the complainant, 6 complainants are without job from over a year, my lord.
After
And-
vacation.
My lord,
After
my
vacation.
lord, if I may, the matter is tagged with a writ appeal, which is for office objection on 3 occasions. It may be listed on for hearing, my lord, because this contempt was heard by this honorable court on 2 occasions.
23rd. 23rd. Along with the writ appeal.
My lord,
Along with the writ appeal.
very well.
23rd.
For hearing, my lord, otherwise it will go for hearing, my lord.
It will, you mention on that. Yes.
Obliged.
34, appearing for complainant.
34, yes. Beyond vacation, 27th of June, as requested.
Madam Lords, AL was pending before the food law. For filing of public interest litigation pending before the law. For filing of mandatory affidavit law, the applicant there was a preemptive order law. Since there was a preemptive order, the appeal became petition became dismissed. I filed application for recalling law. Kindly taken any date.
23rd.
Serial number 25.
Kindly, my lords, serial number 50. My lords, I preferred, my lord, the contempt matter which is tagged along with, my lords, the writ appeal. Writ appeal, my lords, is by the state. My lord, the difficulty is, the non-service of, my lords, notice on the management in the writ appeal, my lord, the matter is not getting heard.
Delay is to be.
My lord, that is there. My lords, the management is, according to, my lords, the causeless is yet to be served. However, my lord, they are represented in my case. My lords, in view of that, my lords, my contempt is also not being heard. My lords, writ appeal is also getting adjourned. If lordships can kindly add notice on the concerned my lord's advocate who is appearing for the management, in our matter, my lords, probably the matter can be considered.
Yes, Mr.
Yeah, very well, my lord. We'll
What is-
take out notice on the council, my lord, if they are willing to accept notice, my lord, in the
So it
writ
is your-
appeal.
Your appeal.
Please, my lord, service to respondent number 213 is awaited, my lord. My learned friend says the council in the contempt petition would accept notice. If that is so, we'll serve the
Whatever
copy,
you
my
want.
lord.
You do it.
Very
For
well.
serial number 25, my lords.
20.
Appear 25. I appear for the appellant. I seek for short accommodation.
There is no short, beyond vacation, as requested. 27th of June.
Oblige.
Date ಕೇಳ್ತಿದೆ, ಗೊತ್ತಲ್ಲ?
So what do you want? What is the request? You just see to it. See to it.
Still,
You can go to the legal service authority for legal assistance. You can approach the secretary legal service authority and get the assistance of a lawyer.
My lord, my apologies, some technical difficulty. He is trying to speak. Can we ask for 15th, my lord? Can we ask for 15th, my lord? He's trying to speak. He can see the court.
You make a request.
Yes, my lord,
What
can
is
we ask for
maximum of
15th?
the mountain?
Can we ask for 15th for his senior counsel's convenience, my lord? 15th of this month, my lord. Writ appeal matter, electricity matter where rules are challenged.
No urgency. Sorry. Challenge to rules, no urgency.
My lord, serial number
It will
46.
come, it will
my
be
lord.
listed in accordance with the, it will come earlier.
My lord, serial number 46, my lord.
40,
46,
40.
connected matters. Similar matter on the 4th July, my lord. Kindly post it on 4th
July.
4th, yes, my lord.
It was stated that the similar appeal is slated to be posted on 4th July.
Yes.
These appeals also shall accordingly be listed on 4th July. What are they? What is the subject matter? The TDS. What is the subject matter? No, then we will not
It
adjourn.
is not regarding the TDS, my lord.
Hmm?
This is not the TDS issue.
We will not adjourn it. Let it be called. You remain there, and unless you know the subject matter, we will not adjourn. Yes.
lords, 50, I request for a shorter date. My pension, my lords, is not yet settled, my lords.
58.
50, my lords, Pfizer, which I made a mention of just now, my lord.
Are you on time?
My lords, if they can serve and get the council, my lords, I have no difficulty to
I
argue.
will get
the
it
matter
done, my
today.
lord. I will get the copy.
Please.
served. Name of Mr. Nagendra Naik is shown, my lord, in contempt. I will get the copy served on him.
Please.
Yes, start.
Serial number 49, my lords. I request for 2 weeks' time.
Serial number?
Serial number 49. 49, my lord.
49. What do you want? 49, yes.
I request for 2 weeks' time, my lord.
Why?
Senior is not in station, my lord.
As requested, stand over to 30th June.
Interim order may be extended.
Interim order is there.
Yes.
Then we will not grant. Come and argue. Yes.
Any other mention through VC, sir?
Yes. Anything? Any further? Yes.
Yes, my lords, I appear for respondent number 1.
Can I make one request, please?
Yeah.
My lord? Kindly grant me 2-3 days time. For this reason, I can secure the sale deed of my grandfather executed by BBMP. There is no marginal land shown in my sale deed, please.
My lords,
I'll have to produce this document before this honorable.
my lords, this is not
But there
some
is no
civil
marginal
suit.
land at all. Madam, one second.
No, no, this
One
is,
second. Let me make my submission. But there is no marginal land at all in
There is
front
no-
of my property.
There is no,
Marginal land, please, my lord. There is no marginal land in front of my property. Lord, the learned single judge, while passing an order, holds that there is a marginal land. Lord, on the earlier occasion, the encroached portion was demolished at the behest of the orders of the learned single judge itself. Now, they did not challenge that order. Now, so abruptly, BBMP takes a stand saying that there is a marginal land. Lord, if my lord permits me to just produce this document, it says on all the 4 sides, 2 sides there is a road, and one side, 2 sides there is a private property.
you are the owner, you are the owner of the road.
Yes, please. my lord.
Adjacent property.
he's the owner of the
There is a
adjacent
footpath.
property.
Adjoining property.
Yes, may I just submit, my lords, kindly see the impugned order. He was not impleaded. He tried to implead. The dispute is between me and BBMP. Kindly see the impugned order. In the
That
impugned
amendment
order,
carried out, correct.
at page 17. At page 17, the last line of page 16. Just for a moment, last line of page 16. The Learned Counsel of BBMP has placed on record a sketch of the subject property in view of the affidavit. Sketch is there. Kindly see the sketch, my lords. There is a small portion with lines which says marginal land. Then there is South Road, entrance for house number 10. And then there is another larger marginal land which is there. Then, my lords, para 5. Srimati so-and-so learned senior counsel submits that petitioner in terms of the above seeks permission to construct a temporary booth using metal sheets in the area measuring 6 feet by 7.9 feet as shown in the sketch. The petitioner will operate this booth without creating any nuisance. Petitioner will occupy such booth till the rules are notified and the petitioner's application is considered. Number 6, Shri so-and-so learned counsel for BBMP submits that petition should be disposed indeed with just directions. However, Shri so-and-so learned counsel for applicants, that is this petitioner, submits that even if petitioner is operating out of this area measuring 6.7.9 feet, the applicants will be prejudiced because the marginal land is at the entrance of applicant's property and they are entitled for such marginal lands. These rival submissions are considered. This court must observe that applicants who do not assert ownership to the extent of 6 feet by 7.9 feet as today cannot claim any interest therein to defeat any equitable arrangement that could be made in favor of the petitioner in light of the fact that he was operating in this area. However, if BBMP has proposed rules for management of its estate with certain reservations for persons with differently abled, the petitioner must avail his right under such rules, and until then, the petitioner who has suffered demolition of his entire construction, including the booth, must be accommodated in a manner which does not create permanent interest. Hence, the following writ petition is allowed with the petitioner to construct a booth measuring 6 feet by 7.9 feet in terms of the sketch and to operate from such booth as a transition operation without causing any nuisance. 2, petitioner would be entitled to use until the 2024 rules are notified. An application filed by him in terms of such rules is considered. The petitioner must also not only remove the debris on the site but also incur all the cost to put up the new rules. The application, that is the impleading application, stands disposed of. It is needless to observe that if applicants make any application after petitioners allotted or otherwise in alternate premises under the rules 2024, they will be at liberty, etc. So now, my lords, his claim before the writ petition was to implead to say it is at the entrance of his land, this marginal land where BBMP itself has identified. Now, my lords, kindly see the photo. The photo is at page 136, where now my friend is changing his position and saying, I own even the marginal land. My lord, that is some dispute that he may have to do with BBMP. They are not a necessary party. They were not, their contentions were not considered. Ultimately, it is BBMP land
which BBMP identified based on directions of this honorable court. A sketch was made, a small area of 6 by 8 feet to just put up a little booth for my livelihood has been identified. Kindly see the photo is also there at page 136, where the sketch is there, which is the land. And in fact, they have put up a car, which nobody knows whose car it is. It is next to a tree, which is a small little area. The learned single judge, in fact, considered all of this, and going by the BBMP's own finding of the sketch and the little portion that is available, has permitted me to put this up until the new rules call for auction, which they have not yet called for auction. The new rules may be introduced, but the auction has not yet been called for. So my learned friend's claim is completely baseless. Ultimately, he does not want me to operate. He's trying by any means to ensure that I am not there. If he has any claim on this marginal land, he has to fight it out with BBMP. We are not here. This honorable court in a writ appeal cannot look at his title documents, which was never the claim in the petition. In fact, the sketch may just be seen, my lords. The sketch, the portion that is actually I am permitted to use is the portion, the marginal land. There is a circle which is actually the tree. There is a small marginal land, and then it says entrance for house number 10. It is, I'm sorry, that is at page number 17, my lords. That is the sketch. It is strictly as per the sketch. You have the other photo, the bigger photo. The sketch, my lords may see. Once BBMP has done an inspection and put up a sketch, in fact, the photo is at
one submission.
No, photo is at
Lord
page
permits me to
136.
read
1 minute,
page 41. That is the order passed by the learned single judge on the earlier occasion. Lord, that paragraph 2, page 41. My learned friend's client is the petitioner before the writ court. The grievance of the petitioner was directed against some of the neighbors who are said to have encroached upon the footpath. During course of these proceedings, inspections were conducted as directed by this court, and reports were filed, which would show that even the petitioner has encroached upon portion of footpath. Lord, it is the footpath area. Lord, and there was a direction by this honorable court to demolish it. That is the order passed on 4th July 2023. Post that, there was a demolition. They have demolished it and kept it. Lord, subsequent to this, there is an endorsement issued by BBMP at page 137. Translated copy is produced at 139. The Lord permits me, I'll read only one portion. Accordingly to the map, the said property was inspected with the assistant executive engineer and his staff, and the existing unauthorized building was built on drainage and public main road, built which was footpath, remaining space of 50-year-old biggest tree. There does not appear to be any space to be provided as requested by Nityanand, who is the respondent. Lord,
what is the locus of my friend to even seek?
Lord, when BBMP itself has taken a stand in the earlier occasion, that too after the orders of the learned single judge, after demolition of the property, that there is no space available. But this fact was not brought to the knowledge of the learned single judge when the impugned order was passed. Now this is a footpath area. Lord, I will go a step further. Lord, that is where I said, if my sale deed, if my Lord permits me to show, then that shows on the eastern side is property number 9, west by KBAR road, north by South road, south by property number 11. This is the sale deed executed by BBMP itself. If there was a marginal land, they would have specified so and so area is a marginal land, beyond it is the property which is sold to you. But that is not done so, please, my Lord. And the third submission, as my learned BBMP advocate has filed the new rules, if those rules are also verified, please, my Lord, BBMP has to maintain a list of marginal lands. That is also not produced before this honorable court. But till all, my only request, my Lord, this is the frontage of my property. If any construction is done to the frontage of my property, my access to my property would be prohibited. My ingress and egress is stopped. But that is what they are intending to. In fact, the learned friend's client has a different property where there is also a marginal land, if at all this is taken as marginal land into consideration, in front of their property. Why can't they put up such temporary bunks in front of their property? Why should they come to my property, my lord?
The petitioner, as respondent number 1 herein, happens to be a person with different ability, whom was allotted a particular shop by the Brihat Bengaluru Mahanagarpalika. Full stop. The said shop was demolished. It appears that the demolition occurred in view of the order passed by this court in writ petition number 5595 of 2023. Order dated 4/7/23 passed by this court in writ petition number 5595 of 2023. Full stop. All those aggrieved whose properties were subjected to demolition approach the court. Paragraph. As far as the petitioner is concerned, he was permitted to construct a shop for his business in a marginal land. The petitioner filed writ petition number 25, instant writ petition number 2544/23, in which he prayed to declare that the demolition of his property, that shop, was arbitrary. Full stop. The petitioner further prayed to direct the respondents to permit petitioner to put up petty shop on the property as the marginal land to continue to enable him to continue to earn his livelihood. Compensation of ₹10 lakhs was also asked for. Full stop. The paragraph. Learn a single judge allowed the petition in terms of the following directions and quote the operative part, page 19 and 20. Pura. The present appeal is filed by the present appeal is filed by the
Impleading appeal. I had filed an application for
He had
impleading
filed an impleading application.
before the writ court, please.
You want to dictate the order? Please take your seat.
Please. I'm sorry.
Clearly. By original respondent 5, who was not party to the writ proceedings initially, but upon application filed for impleadment, ordered to be joined, permitted to be joined as per order dated 10/6/24. The appellant is the owner of adjoining property. While allowing the petition, paragraph, learn a single judge verified the aspect that the shop of the petitioner, as originally stood before demolition, was on the marginal land. Full stop. A report was called for, which was filed on 2/7/24 along with the photographs. Full stop. Learn a single judge observed and recorded finding on the page of the said documents that a standing tree and marginal land was in existence where the petitioner was permitted to, which place was petitioner was permitted to occupy. Paragraph. Learn a single judge thereafter observed in paragraph 4 as under. This court had careful correction. paragraph. Learned single judge required the petitioner to ensure that the debris at the subject property are cleared, debris at the place are cleared, and that the area at measuring 10 to 8 feet would be permitted to be occupied as it was earlier in occupation, as was in occupation earlier. Also, the petitioner was permitted to put up only a temporary structure made of metal and sheets. Furthermore, a sketch was produced by a learned advocate for the West Bangalore Mahanagarpalika, now into bracket BBMP, depicting the locations, including the place to be permitted to be occupied as a marginal place by the petitioner. Learned while learned advocate Mr. So-and-so Manjunath for the appellant would submit that the permission to the petitioner to occupy the marginal land would affect his right to enjoy his own property, learned advocate Srimati Jaina Kothar for original petition was justified in contending that the appellant was not a party, and that even otherwise was not a party to the proceeding initially, but he was subsequently joined, and that his contentions were his case was considered by the learned single judge for allowing the petition in terms of the directions as aforementioned. Full stop. She further submitted that she was right in further submitting that the lease is essentially between the original petitioner and the BBMP, and the marginal place which is permitted to be occupied to the petitioner by the petitioner belongs to the BBMP, and the appellant has no concern as such in respect of the said land and the enjoyment thereof by the petitioner as granted by the BBMP. Learned single judge paragraph. In the context observed in paragraph 7 of the judgment, that the appellant do not assert ownership to the extent of 6 feet into 7.9 feet of the marginal land permitted to be occupied by the petitioner, and cannot claim even an equitable right therein. It was clarified by learned single judge that the BBMP had proposed to frame the rules for management, and that the petitioner, while availing the right to occupy the marginal land, shall abide by the rules as and when finalized. Full stop. At this stage, learned advocate Mr. Subramaniam, appearing for BBMP, submitted that the rules called Bengaluru Mahanagarpalika Act or rules?
Next page.
Rules called Bengaluru Mahanagarpalika Integrated Estate Management Rules 2024 has been finalized as framed in exercise of powers under section 316, read with section 66, 67 and 130 of the BBMP Act 2020, and the same are notified in notification in the government gazette notification dated 1/1/25. Full stop. The gazette copy of the gazette notification was produced before the court. It was stated that the occupation of the petitioner shall be guided by the provisions of the rules. Full stop. In this regard, learned advocate for the original petitioner stated that, as directed by learned single judge, as contemplated in the operative part by learned single judge, the permission to the petitioner was a transitory in nature, in the sense that now, in view of the coming into force of the rules, if the petition is required to apply,
We have to apply. Until my application is considered, I can continue.
apply under the rules, the petition will apply to be considered, to get it, to get his application considered along with others
Yes.
in accordance with rule,
Yes.
to be done by the BBM.
Yes.
Full stop. With limited clarification and observation as above, no case is made out by the appellant to interfere in the judgment and order of law in a single judge. The appeal fails and it is dismissed.
And my lords, one more line, my lords, my request that for me to put up this booth, as per the terms of my lord's clarification, the police assistance, if any, or any other assistance, because I'm not able to put up my booth. They are objecting to such an extent that I'm unable to put up the booth. To that extent, my lords. I have to put up this temporary booth.
The BBMP shall permit the petitioner to put up the structure as per the observations and directions of a single judge, and if necessary, shall ensure the protective measures.
I'm grateful.
Lord, one last submission. I have also filed an application, Lord. That also may be considered for marginal.
Everybody can file, no?
Lord, otherwise, my lord, it is only their application which we will.
You have said that along with other applications,
including the appellant.
No,
It may be mixed.
How can you have margin?
My lord, it is in front of my
That
property.
will travel little giving something which is not due. You can get it, you can file, no difficult.
I have already filed.
Grateful. my lord.
Observation may not be called for, yes.
Much obliged.
Obliged.
Grateful.
Complaint.
Bill number 2.
For the complaint in this matter, Lordship.
What did you do after the order?
23 days delays.
Lords, we
23
have
days
already
delays.
filed our compliance affidavit in this matter.
Copy is not received,
file.
Lordship.
Compliance is filed.
Copy is not, sir.
Supply the copy. So it is decided?
Please, my lords, it's been decided.
Learn a single judge, as per order dated 13th March 2023, set aside the order of respondent 1 dated 4/1/2020 and remitted the matter back to state respondent for press consideration. Full stop. Compliance affidavit is filed pursuant to paragraph. Pursuant to the filing of the contempt petition with regard to the aforesaid direction, compliance affidavit is filed, on the basis of which learned additional government advocate Srimati Prabhandini Kishan would justifiably submit that since the remand proceedings are decided, the compliance is, the order is directions is complied with. Full stop. The factum of the decision by the competent authority upon remand would not be disputed by learned advocate for petitioner Mr. So-and-so, so-and-so, paragraph. In the aforesaid view, nothing survives in the present proceedings. The contempt petition does not survive.
Lordship, liberty may be, Lordship.
At this stage, learned advocate for the petitioner request that the liberty may be reserved for the petitioner to challenge the endorsement in question, decision which is taken on remand by respondent 1. Full stop. Such liberty is reserved, however, in respect of such recourse, this court does not express anything